All right, we're recalling the case. Let me start this up. Recalling the case of the People State of Michigan versus Jesse Joe Frederickson, file 21-0429FY. Counsel, identify yourselves for the record.
Good afternoon, Your Honor. Jeffrey Reddick on behalf of the people.
All right, Leland Burton for Jesse Frederickson. She's present, seated to my left.
Where was she this morning at 9 o'clock?
I was actually at work. I thought this was in June, not May. I have the court
None of your
papers on.
paperwork says June. It says today.
I see that. I had the dates mixed up, Your Honor.
All right. We had a warrant out for your arrest. What are we doing with the file, Mr. Burton?
Your Honor, my client, the prosecuting attorney's office have offered an amended count 2, child abuse in the 4th degree, which is a misdemeanor offense. In return for a plea of guilty to that, they will dismiss the original charge of child abuse 3rd degree.
Okay. And then child abuse 4th, is it 4th degree that she's
4th degree is
pleading
a
to?
1-year misdemeanor offense.
1 year maximum penalty?
Yes,
Correct.
Your Honor.
All right, Mr. Reddick, that's indeed the offer.
It is, sir.
All right. Mr. Burton, may I address your client regarding the offer?
You may.
Mr. Frederickson, the prosecutor's offered a misdemeanor, 1 year misdemeanor. Doesn't mean that's what you'll get. That just means it's the maximum penalty that you could receive. I don't know what I would send you to. I want to find out a little bit more about the facts and circumstances of the case because I don't know anything about the facts and circumstances of the case. And then we'll obviously take into consideration how you do between now and the time of sentencing. Are you planning on following your lawyer's? Well, let me ask, Mr. Burton, is it your advice that your client accept the offer?
Yes.
You planning on following your attorney's advice and accepting the offer and entering the guilty plea to the child abuse 4th degree?
Yes, Your Honor.
Okay, stand up, raise your right hand, be sworn in. Why don't you take your mask off? It'll be easier to hear you. Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you seated. Katrina, can you hear her okay?
Yes, Your Honor.
While you're talking, you can have your mask down. It's just too hard to, and the microphone is a little red thing that's down in front of you there, so you might pull it up just a bit. The promises stated on the record are the only promises that I know about. Has anyone promised you anything more than this or threatened you in any way to get you to plead to this reduced charge when you really do not want to?
No, Your Honor.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, Your Honor.
If you enter this plea, you'll be waiving some valuable rights. Those rights are a right to a trial by jury, or if you, Mr. Burton, and the prosecutor agree, a trial by bench, which would be me to listen. I would listen to the facts and decide. You'd be waiving the right to remain silent, not have your silence used against you, the right to be presumed innocent if the charge still proven guilty beyond a reasonable doubt. The right to hire your own attorney. I think, Mr. Burton, you're appointed on this case.
I am.
And the right to represent yourself. You'll be waiving the right to confront your accusers, call witnesses, and testify. Do you understand each of these rights?
Yes, Your Honor.
You would have to waive these rights in order for me to take this plea in this case to this charge. Do you waive those rights?
Yes, Your Honor.
Took me a minute to pull it up. How do you plead to an added count 2 of child abuse 4th degree? Do you plead guilty, not guilty, or stand mute?
Guilty.
On or about March 11th of this year, were you at an address at 83 South 8 Mile Road in Lee Township, Midland County, Michigan?
Yes, Your Honor.
Mr. Burton, I'm unfamiliar with enough of the facts of the case. Are you willing to ask questions to obtain the factual basis?
Sure. Jesse, you weren't the only one there at that location, correct?
Correct.
Also present was your son, Dominic, correct?
Correct.
How old's Dominic?
He just turned 8.
And at that time, Dominic was present at the home. You began to tattoo his hand, is that correct?
Correct.
And as a result of that, he sustained physical injury or harm, is that correct?
Correct.
And you knew at the time that you were doing the tattoo that some injury would recur because it was tattooing, correct?
Correct.
Thank you. I have nothing further, Your Honor.
Have I, with that factual basis, complied with the court rule and had a factual basis, Mr. Burton?
Yes, Your Honor.
Mr. Reddick, do you agree?
Yes, Your Honor. I believe that satisfies the statutory requirement of either an intentional or a reckless act that either could or did result in harm, and I'm satisfied.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in records of the court as count 2, which is child abuse 4th degree, A maximum penalty of 1 year misdemeanor count 1 and the habitual offender 4th will be dismissed. I'm going to set this over for a pre-sentence investigation. I want to find out what is happening. Are you currently under pretrial services with?
If I may,
Yes.
Jesse's actually on my hope with Brianna Varner.
Okay.
I actually met with Brianna Varner, and so did Miss Fredrickson, actually. So Brianna's up to speed. Not that a plea just entered, but we've kept her informed as to what's been happening here and what the allegations were. So Jesse will continue to work with my hope and its programming. So we would have no objection should this court want to reach out to the 42nd Circuit for information and compiling a PSI.
We'll do that. The other piece that I was curious about was
The
when
bond?
the bond was initially set, was there a pretrial services order? Probably not if she's on my hope.
I didn't recall there being one on the bond.
Okay. I just need Ms. Fredrickson to sign a release so that we can actually talk to my hope coordinator. I think that's probably part of the program, although I'm not certain of that.
It could be. I don't know.
All right, so I'm just going to leave bond in its present state unless there's something we need to address regarding that. Mr. Reddick?
I have nothing, but I believe Mr. Burton may address the no contact.
Correct, Your Honor.
Go ahead.
Currently, there's a no contact provision with Dominic. You heard the allegations and the facts and circumstances surrounding this. We didn't try to hide anything during the taking of the plea. There wasn't further sustained damage or anything. There was minimal, if any, CPS involvement. Dominic is currently with his father. There's been a matter pending in front of Judge Beal with regards to custody going forward. We would simply ask that the no contact provision with Ms. Fredrickson be lifted so that she can have some form of parenting time with Dominic at this time.
You said there was minimum CPS involvement. Are they involved still at this
My
time?
understanding is once Dominic was placed with his father, CPS's involvement ended.
Okay. Mr. Reddick, any position regarding the request?
Yes, Your Honor. I'm not really sure, given the nature of CPS and their policies, if they're given that there was a placement with the father, I wouldn't want to put him behind the 8 ball of allowing visitation and having there be a failure to protect. What I'd ask is that the court would withhold making this determination at a minimum until probation departments had an opportunity to speak with pretrial services upstairs, or Ms. Varner, or until the time of sentencing. I think that would protect the best interests of all, paramount the child.
Okay. I'm not opposed to the idea. The concern I have is the same as Mr. Reddick, is if we allow that, or there's an order and then a visitation comes, and then Dominic could end up potentially in foster care because of the father not protecting the child. I want to make sure we've cleared all the hurdles regarding CPS first. So I'll set this over for pre-sentence investigation. Katrina, can we get a date and time for sentencing?
Yes, Your Honor, that would be June 12th at 9:45 a.m.
What I will do is lift the no contact order with respect to non-physical contacts. She may make a telephone call or text message. Obviously, would think it'd be age appropriate, and 8-year-old's going to try to figure out what exactly is happening. So I would presume that Ms. Fredrickson would look to the concerns of her son and not make him feel like he's in the middle of a custody dispute. Is my understanding that there is one, that wouldn't become an issue. And also if there's any counseling that's ordered, that I would allow the physical contact for counseling purposes. It's sentencing once
Your
I know
Honor?
a little bit more. Yes.
I'm sorry, I apologize. I believe I said June. It should be July 12th.
Okay, I wrote June 12th, so July 12th is sentencing. And at any point in time, if probation department makes a determination, we can set a request regarding bond between now and July 12th. But we'll allow non-physical contact, meaning telephone call or text message. I am not overruling whatever another circuit court judge says, however. So if there's an order, Mr. Burton will explain that. If Judge Beal, I don't know if it's Judge Beal or Judge Karras, you have 3/4 of the judges. So you've got Judge Karras probably for my hope.
Yes.
You got Judge Beal for the custody issue, and you've got me. So if those two have something that they say, I'm not overriding what they say. So if Judge Beal has an order saying you can't have contact, I'm not overruling Judge Beal's order. I am saying I would allow non-physical contact. But if Judge Beal's order says none, then Judge Beal's orders win.
Right.
Does that make sense?
Yes.
Okay. Anything else we need to place on the record to make things with more clarity, Mr.
No, sir. Thank you.
Mr. Burton?
Nothing, thank you.
All right, so I will put, who do we have, court officer? Deb, if you would have a note on there that the probation department would be in contact with My Hope regarding any bond terms. We're just going to adopt the My Hope program as the bond terms for this case. And if they do get information regarding CPS, they can make a recommendation regarding the no contact order before July 12th. I would be all right with that. We just need to give notice to the father, because he would be listed as the victim. In this case, the law in criminal law says if you have a minor child, then any parent could be the victim. In this case, the father would be the victim that we need to give notice to. All right, we'll be adjourned on this case. Thank you.
Your Honor,
Thank you.
Yes,
are we reinstating the bond that was previously set then?
I am. Yep. Ms. Frederickson has stated that she messed up and put down the wrong date. Plenty of interaction with Ms. Frederickson. She may make mistakes, but she usually shows up to court.
I've never missed one.
I don't think she usually does, and if she doesn't, her mom will make sure that she does. So
That's correct.
nobody wants that. All right, we'll be
Thank you,
adjourned.
Your Honor.
Thank you. Now calling the case of the people of the state of Michigan versus Joseph Travis Holland, file 210518FY. Counsel, identify yourselves for the record.
Good afternoon, Your Honor. Jeffrey Redding on behalf of the people.
Leland Burton for Mr. Holland, Your Honor, is present and seated to my left.
All right, today's time and day set for preliminary examination. Is that correct? Is everybody ready to proceed?
We are, Your Honor.
Yes.
Defense. All right, so a couple things before we get started. The individuals who are speaking, I'm going to put my mask on now that I'm not speaking. I'll put my mask on. If you're testifying, you can have your mask off or leave it on, whichever one you're most comfortable with. In circumstances for Mr. Holland, because this system, you see the red microphones, this is fairly new. If you want to have a private conversation with Mr. Burton, our microphones pick it up, so you're not private. So if you float your finger over the top of the little button there, it turns it to green.
Okay.
When it turns it to green, then that microphone's not picking it up. We've had a lot where I can't hear you, but my staff tells me that they can hear what you're saying. And so you're not having a private conversation if you think you are, unless that thing shows green. Why it's green to stop and red to go, I didn't design the system, so I have no idea. But that's the way that it is. You see red, it's recorded. All right, same is true with prosecution, but typically it's not a constitutional right or concern at that point. All right, let me pull my spreadsheet up so I can take my notes. All right, Mr. Reddick, your first witness, sir.
Your Honor, I just have one preliminary matter. I've discussed it with Mr. Burton and advised the court staff of it as well. It's our intent today, pursuant to our demand for the preliminary examination, that we will be calling Mr. Brown as our first witness. And at the conclusion of that testimony, I'm going to be asking for the waiver of the preliminary examination.
Okay.
And I believe that would be consistent with Mr. Burton's client's position.
All right, Mr. Burton, is that correct?
Yes, my client and I spoke about this. We're going to be executing a waiver of the preliminary examination post-testimony.
All right, both parties have a right to preliminary examination. The prosecution is requesting one until the witness, Mr. Brown, testifies, and after that, they decide to waive it, they'll waive it. And I'm ready to take whatever testimony we have.
Thank you. We call Peter Brown.
Mr. Brown, please come forward. Why don't you get him right up to the chair and then I'll have him sworn in. Just before you take a seat, if you would, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, go ahead and have a seat. Mr. Brown, you are welcome to take your mask down to testify, but if you're uncomfortable, leave it up, but you're going to have to enunciate pretty clearly. I have very few people don't take me up on that request. So. All right, you're a witness, sir.
Thank you. Good afternoon, sir. Could you tell us your name for the record, please?
Peter Paul Brown,
And Mr. Brown, your current address?
4920 Art Crest, Apartment 1,
What's your date of birth?
August 12th, 1963.
What do you do for a living, sir?
I had worked at Kroger as as a greeter. I've been a laborer most of my life.
Understand that you've lived in Midland for quite a few years?
For the last year or so, I grew up here, lived in Saginaw most of my adult life. Now I'm back in.
Very good. Do you
Your
know
Honor?
what person?
I'm
Yes.
sorry, Mr. Reddick. Could I have the witness move closer to the microphone if at all possible?
Mr. Brown, yeah, if you move towards the red light
Thank
there,
you.
that would, thank you. All right, go ahead.
Thank you. Do you know a gentleman by the name of Joseph Holland?
Yes,
And is the person you know is Joseph Holland currently in the courtroom?
yes,
Could you point him out and describe what he's wearing, please?
orange,
Thank you. Would the record reflect the identification, Your Honor?
Any objection or voir dire?
None.
The record will reflect the witness identified the defendant.
Thank you. Mr. Brown, when did you first come to meet Mr. Holland?
probably right after New Year's.
That would be of this year, 2021?
Yeah.
And how did you come to know him? What was his relationship with yours?
Just the guys in the neighborhood to get together and have a drink or two sometimes, and he'd be there.
All right. Did he have a relationship with anybody in the close proximity to your home?
Yeah, a neighbor that lived a few units down,
And what's that person's name?
Melissa.
How long, do you know Melissa's last name?
Really don't.
All right.
I had talked to her before, but
It's my understanding that you live on the apartments. I think we're all familiar with the area, the Artcrest Apartments on Artcrest near Frick's Bar.
Yeah.
And you lived in apartment number 1.
yes.
And Melissa, do you know what apartment she lived in?
No, it's 3 doors down toward the north.
Same building?
Yeah.
All right. Did you have contact with this Melissa before you knew Mr. Holland?
Yes.
So you were on good terms with her?
Yeah.
And you state that Mr. Holland showed up amongst the group of neighbors or friends that would gather sometime after the first of the year.
Yeah. And
I want to take you back to the date of April 9th, 2021. That would be, I believe, the date that you ended up at the hospital. Do you recall that day, sir?
earlier in the day, yeah.
Very good. Were you at your home on Artcrest that day?
Yeah.
And did you come in contact with Mr. Holland that day, early in the day?
Not that I remember, not till the dumpster.
Prior to the time that you say you met him at the dumpster, let me ask you this first. What time was it, if you know, that you met with him at the dumpster?
1 in the afternoon, 1:30 maybe.
All right. And how do you know that?
I was putting kitty litter bags in the side of the dumpster because I couldn't get them in the top, and I heard someone yell, "Hey!" I spun on one knee because I was on one knee, and I saw him and I saw the bat come.
Okay. Let me slow you down here first. This was approximately between 1 and 2 in the afternoon.
As I remember, I think.
Okay. Was it daylight out?
Yeah,
All
I
right.
believe so.
Do you recall what other things you had done that day at all earlier in the morning?
Vacuum my apartment.
Typical day around the
Yeah,
house?
played with my Kylo.
All right. And you state that prior to that time, you had no contact with Mr. Holland that day.
Not that I remember.
You state that you went out to the dumpster to throw away some cat litter and that you met Mr. Holland, or Mr. Holland, you saw Mr. Holland at that point. All right. Tell us what occurred between you and Mr. Holland.
I was putting the last of a bag in the side door of the dumpster. I was on one knee because I had to cram it in. There wasn't much room to get it in. I heard, "Hey!" I spun because I was on one knee. Saw him, saw object smack me. Then all I did was tried to cover up, roll, put my legs up, just kept taking beating after beating.
All right. Now, you state you heard a yell of, "Hey." Do you know who stated, "Hey"?
He did, because I saw him before the bat hit me right between the eyes.
And when you say him or he, you mean
Mr. Holland.
Mr. Holland. Okay. So you saw him with the weapon before he struck you.
I saw him as he was swinging the weapon that hit me right in the head.
Any mistake in your mind that it was Mr. Holland?
No,
How many times did he strike you in the head with the bat?
couldn't count them.
More than,
All I was trying to do was survive, stay alive. I rolled, put my arms up, put my legs up, turned to my side, put my arms up. I took a hell of a beating.
what's the next thing you remember, Mr. Brown?
I hollered a few times, stop. Then I hollered, stop or you're going to kill me. Then I was out. Next thing I know, I woke up at Hurley Medical.
In Flint, Michigan?
Yeah.
Can you tell the court what injuries you've suffered?
According to Hurley trauma, broken skull, broken nose, broken jaw, crushed larynx, broken ribs, numerous bruises, lacerations up and down my body everywhere.
You had some surgeries, I understand.
Yeah, got plates in my jaw to hold my jaw together. They did something to my sinus cavities so I could breathe through my nose. My esophagus is still messed up where I have panic attacks where it'll close on me when I'm just standing there in my apartment. I can't breathe for a minute, minute and a half.
So I understand you've had some people take care of you.
Yeah.
Your family's been helping out?
Oh yeah, big time.
Very good.
Yeah.
Haven't had any contact with Mr. Holland
No.
since then?
No.
Do you recall at any time going to the Midland Hospital with him?
Oh, I don't remember anything except waking up at Hurley.
Okay. And you know that was the next day, I believe?
I don't know.
Very good. I appreciate your candor with that, sir. Thank you. This all occurred here in the county of Midland?
Yeah.
Back in early April 2021?
Yes.
Thank you. I've got nothing else, Your Honor.
Cross-examination?
I'll be pretty brief. Mr. Brown, you said Mr. Holland said, hey, you looked up and saw him. Do you remember saying that? And you have to say yes or no, okay, because we're being recorded.
Yes.
Thank
A
you.
loud voice to get my attention.
Yep.
So I looked toward him.
Other than hey, was there any other statement made by Mr. Holland during this incident?
I don't remember. I don't know.
And it was your testimony today that earlier that day you'd played with a cat and vacuumed your apartment, but you did not have any interaction with Mr. Holland earlier that day, correct?
Not that I remember, sir.
Do you remember any interaction with Mr. Holland the day before this incident occurred at all?
No, I can't remember anything anymore. Not really. I'm fucked up. Excuse the French.
I just had a time or two in my life too, so. All right. I have nothing further, Your Honor.
Any redirect?
No, thank you for the opportunity, Judge. I have nothing else.
May this witness be excused?
We asked that he would be.
Any objection?
Objection.
All right, thank you, sir. You're excused.
That'll help you get around here. Your Honor, with that testimony, we would waive the preliminary examination.
All right. Mr. Burton, is your client planning on waiving the preliminary examination?
Yes, Your Honor.
May I address the waiver with him?
You may.
Mr. Holland, your attorney is recommending that you waive, and I believe that is your recommendation, is it not, Mr. Burton?
Yes, Your Honor.
That your attorney's recommending you waive the remainder of the preliminary examination. Do you understand what the preliminary examination, we're kind of in the middle of one right now.
Yes, I understand.
Okay. His recommendation is that you waive the remainder of the preliminary examination. Are you planning on following his advice?
Yes, Your Honor.
Okay, I'm going to make the determination that the waiver has been made knowingly, understandingly, and voluntarily. Matter is now bound over to circuit court. Mr. Reddick, I presume with the testimony that was taken just from Mr. Brown, there's nothing in that testimony that I could hear so far that would seem that you're planning on increasing or adding to the count. So can I rely on that the felony information that was filed is the correct one for circuit court arraignment purposes?
Correct, Your Honor.
All right. Mr. Burton, is your client familiar with the charges and the maximum penalties as they are in the felony information?
Yes, and I've made him aware of the fact that there's a 25-year mandatory minimum notice that's been filed with the prosecutors as well.
All right. How does your client plead then or I presume you do not need me to read the charges then again. too.
No, we would waive the reading of the information, Your Honor. I would ask that the court enter a not guilty plea on the client's behalf, and we have no objection to bond on its current terms.
All right. Anything further from the defense then?
Nothing. Your
Anything
Honor.
further from the people?
No, we're satisfied. Thank you, Judge.
All right, I am as well. The bond will be continuous present form. Will be adjourned. Thank you.
You betcha. Thank you, Judge.